So I put on YouTube, I have videos that I've done for my clients. I have about 4 or 5 of them. And I write them a letter or I email them. I say, watch these videos, so that it cuts out 20 minutes of my depot prep. I found that I was saying the same thing over and over. So what I do is I have them watch these videos, and you can get them on my website if you want. And then when they come in, then they've gone through some of the preliminaries, and I also can tell whether or not they're a stakeholder in this, whether they've even watched them or not. So it's really beneficial. I run through basic preps for every witness. Remember that you got to understand the question. If you don't understand the question, there's 2 ways to deal with it. Either say, I don't understand the question, repeat it, or you answer any ambiguity of the question with your answer. Like, well, if you mean 2 weeks after the accident, this is the pain I was in. If you mean a year after the accident, this is the pain I was in. You need to have them listen to the question. The mind works about 100 times faster than the mouth, as you can tell how quick I'm talking, right? So by the time a question is asked, the person has already heard it, formed their answer, and are ready to answer. So they don't listen to the whole question. So you need to tell them, listen to that whole question, because it's a lawyer and they may trick you. I don't know is an okay answer. They don't need to know the answer to everything. And a lot of this is obvious. I know you guys do this all the time. So, but they don't want to just, you can't overemphasize that. You know, prepping these witnesses is always I used to say these were rules, now I call them guidelines, because then you get the witness who says, I don't know to everything, and it kills your case because they can't talk about their own pain and suffering. So you got to balance that. So these are suggestions. So you say, you know, if you don't know anything, I don't know. If you know a little bit about it, give them your best guess. And that's when you talk about levels of recollection with a witness. Role play with the witness. Be the other lawyer. Take them through the hard questions, and take them through the medical, and get their game face on. Start practicing with them, and they'll get it right away. And they'll start answering the question rather than doing a la-di-da story in response to what's your middle name. Do that. Tell them to focus on that question. Get them to answer that, and then you work through that, and then they get their game face on for the depot. Fix the real problems in your case in the prep. Why did you delay treatment for a month? Why did you rear end that car going 80 miles an hour? Fix those things right away, because that's the key stuff. You can go on and meander around about the nuancy parts of the case, but zero in on the essential stuff. That's more effective. And you need to tell these folks, make sure the answers are fully accurate. If you're letting the other lawyer affect you or push you around, you're not telling the truth. You're not, and that really gets to people. There are some lawyers who lead with the hardest questions. On the defense side, I find, don't you have to look where you're going? Don't you have a responsibility to pay attention to where you're going? If it's a slip and fall case, you're on the plaintiff's side, your client better have a good answer for that. And the reality is, when you walk around, sometimes you look down, sometimes you look up, and so you need to context that and vet that. So in your witness prep, review the documents, go through that, interrogatories, petition, medical records, get them to understand what their ROG answers were, the petition, the dates. Go through the medical. It's very effective on the defense side to sit and say, how did you rate your pain the day after the incident? And then the medical, it's different, or 3 weeks after. Give your client a context of that, because they're not going to remember that. Have a medical summary, talk about that. On breach of contract cases, employment cases, long-time term cases, talk about the timelines, the dates of events, when things were said. Give them a context of it, because unless you orient them, they're not going to remember that in a vacuum. You find out that the better preparation you do with a witness, the better their depot goes. Every time, it seems like every time that I've walked out of a depot and said, man, boy, we really screwed that one up, I look at myself and I say, you know what, I forgot to say this to him, or I really didn't spend the time, or I forgot to ask them if they saw my videos, or I didn't go through the medical and make sure they knew how they rated their pain. So that's an idea. One of the other things I say is, everything ain't possible in a deposition. If we're sitting on the porch having a lemonade, you say, ain't it possible at such and such and so? In a depot, it isn't, because that's a trick some lawyers use to say, now, isn't it possible that someone wasn't negligent or something else happened. And it kind of is, you know, but in a depot, you got to stick to your guns. You got to say, no, it's not possible that I was negligent. No, it was not possible for us to clean that ice off the street. Or it wasn't possible that I had another injury. It wasn't, because I know that's not true.